hits it itself, sometimes you gotta go in, because it'll talk back the 15-second photo. All right. If you can't tell, Mr. Leiker was in the courthouse in another hearing, so he just appeared here personally. Anybody need anything to talk about, anything before I call the cases? Nope, nope, I'll take silence as no. All right, let's be on the record in 3 cases, those being 2019 CR 951 through 953, captioned State of Kansas versus Dimitri Irvin, DeLeon Henderson, and Tobias Womack. Would the parties announce their appearances, please?
May it please the court, the state of Kansas appears to Assistant District Attorney Adam Sokoloff.
May it please the court, Defendant Irvin appears by video conference.
Jeff, speak up a little bit, please.
She asked you to speak up.
I know what you said, but for future reference.
Oh, I got you. Did you get my appearance?
Except which defendant you're representing.
Dimitri Irvin.
I'm sorry, one more time.
Irvin?
Irvin, thank you.
Mr. Stone?
May it please the court, DeLeon Henderson appears through Gary Stone.
You're muted.
Still?
No, now you're good.
DeLeon Henderson appears through Gary Stone.
And Judge Tobias Womack appears in person by video by and through counsel Michael Duma.
All right, we're here set down for a couple of reasons. First and foremost, Mr. Duma filed 2 motions for discovery. My understanding is that the first one, the parties reached an agreement and Mr. Sokoloff provided what was requested. The second one, we need to have a hearing on. Do I have that correct, Mr. Sokoloff?
Yes, Your Honor, that's correct.
Mr. Duma? You're muted.
That is correct, Judge.
All right. And I take it, Mr. Stone, Mr. Leiker, that you have joined Mr. Duma in his 2 motions.
Yes, Judge.
Certainly.
All right. Mr. Sokoloff.
Mr. Duma's second motion would be inapplicable to the other 2 defendants as they don't have standing.
All right. So those items, those
I
police
disagree with that.
Go ahead.
Well, I mean, I don't mean to advocate for them, but generally, I think the police reports I'm asking for will identify, I'm not sure who, but they will identify individuals who have been involved in shootings associated with the vehicle in question in this case. And so as it would act as a defense for my client, it would also, I think, act as a defense for the 2 passengers, alleged passengers of the vehicle, in that perhaps, you know, they too had a mistake of identity.
All right. Well, I suppose it doesn't really matter if I grant the motion or deny the motion, whether or not the other 2 are parties to it. I guess we can cross that bridge if we have to after I hear the motion. All right. Before we get into that, Mr. Stone, you had mentioned when I inquired about what we were going to be taking up today, that you also wanted to address some other issues. Why don't we do that, dispose of that, get that out of the way, and then we can move on with the discovery motion. Mr. Stone.
Judge, and the thing that I was concerned about is that my client, as well as the other defendants, have not yet had anything put on the record regarding the Supreme Court's rulings with speedy trial and staying the proceedings. There isn't anything put on the record regarding the court's ruling on preliminary hearing. It's my understanding, and again, just for the record, that the court has stayed the speedy trial in this matter at the Supreme Court, that the court has denied our request to dismiss the preliminary hearing based on its I'm not sure if the document was ever filed, but it was at least mailed to me. And I think that just needed to be put on the record, thereby advising the defendants of the current status of the case. That's all.
All right. I'm going to check full court here and make sure, but I know that I sent that document to be filed. We'll find out. Because if it hasn't been filed, it needs to be.
It may have been filed. I'm not sure.
It has not. I'll see that it is. All right. Denise, I think you have, I don't know if you have it. Remind me before we get done today to make sure that my opinion in this case gets filed. All right. Okay. So as Mr. Stone correctly noted, I did take up the defendant's joint motion for dismissal following preliminary hearing. And per that order that I provided to the parties, but apparently has not been filed, I denied said motion. And Mr. Stone is correct in that at this time, at the direction of the Supreme Court of Kansas, timeframes regarding speedy trial are stayed. Recently, they lifted many other stays on timeframes, but they specifically excluded speedy trial calculations from that relief of order. The original order from the Supreme Court was that once the emergency order is lifted, that speedy trial will be calculated at 150 days from the lifting of that order. And that has been construed to apply to cases that were on the clock before the emergency declaration that went on the clock subsequent to in equal manner. So for statutory speedy rights purposes, these are stayed, and upon lifting of that stay, it will be 150 days from the lifting of the stay. Now, I'll tell you this as a practical matter. What this court's intent is when we are allowed to set jury trials again is to address first and foremost those people who are in custody. They will get priority. Secondly, those who went on the clock before the declaration of the emergency will also get priority in the next step. In these particular cases, these defendants meet most of those priorities, both of those priorities, that they are in custody and that they were on, well, but for the pending motion, would have been on the speedy trial clock. So I can assure you this, that these cases will be among the first set once I'm allowed to set trial. Now, when it comes to constitutional speedy trial, there is no authority for anyone to suspend a constitutional right to speedy trial. But there's no specific dates or time limits put on the constitutional right to a speedy trial. In Kansas, through Supreme Court cases, it has been a weighing exercise in which you weigh the reason for the delay, the prejudice to the defendant, their own, cause or acquiescence to such a delay. I would note for the record that the defendants have not caused this delay, nor have they acquiesced to it. So it's always possible for someone to seek a finding at the end of this that somebody's constitutional speedy trial was violated. Now, I can't imagine a scenario in which the Supreme Court will tell us you can't have jury trials and speedy trials are suspended and then turn around and find because of that reason someone's constitutional rights have been violated. But I'll leave that all to council to argue. It is really an issue of first impression at this time. All right. So we addressed the speedy trial issue. We addressed the denial of the motion to dismiss. Anything else before we take up Mr. Duma's second motion? All right, Mr. Duma, would you like to add to that motion today?
Judge, these young men are accused of committing a shooting on August the 13th. I know you've had a chance to review a transcript of the preliminary hearing, so you have some idea of what the facts are. On August the 7th, a GPS tracker device was placed on a white Dodge Charger, which ultimately was a key piece of information in establishing that that Charger was involved in this shooting. And so prior to that tracker being put on, Judge, the detective filed an affidavit with the court. That is what my original motion requested, was a copy of that affidavit. When I got that affidavit, it listed a number of, I'll call them events that occurred in the weeks preceding this shooting, and they all centered around some sort of white Dodge Charger. Now, there were various shell cases located at different shootings, but essentially there were 6 different instances spanning from June 28th until up until just shortly before the search warrant was obtained on August 7th, that involved this alleged white Dodge Charger. What is really of note, Judge, is that in at least 2 of these, there was evidence, at least in the affidavit, that Tomias, with an M, Womack, who is my client's brother, was present and involved in incidents which this vehicle was seen at. Those involved shootings. And Judge, I think if there are other individuals driving this vehicle around in the days and weeks preceding this murder, and they are committing crimes with handguns that are similar to the ones involved in this murder, then we need to look at that evidence to see who those people are, or at least what evidence exists as to the identity of those people. Because if it says it's anyone other than my client or the 2 gentlemen sitting next to him, we need to know that, because that would be relevant evidence in establishing that this is not solely a vehicle operated by my client. And Judge, not only for that reason, but I think I'd have the right to the reports, if nothing else, to verify that the contents of the affidavit are true and accurate. That for the GPS tracker that was placed on the vehicle, which ultimately became a major part of this case. And so, I think there's a Fourth Amendment issue that seriously needs to be explored, and that cannot adequately be explored without those records, Judge. And finally, what I'd say is, I'm asking for these records. I'm not, I understand the state's objection will probably be that they're an ongoing investigation and that they shouldn't be released, at least in part for that reason. But Judge, they could be produced to me under an order not to disclose them. They could be produced to me in 100 different ways that would not jeopardize whatever. I don't know what the actual investigations are ongoing, but in a lot of different ways that would not jeopardize those investigations. So I think that the necessity of them versus whatever objectionary basis the state may have is weighed in our favor, Judge.
Mr. Sokolow.
Well, I guess first, Your Honor, I think I'm pretty confident that Mr. Duma's and all counsel's response, if I said I intended to introduce the alleged allegations from the tracker affidavit as 6455 evidence, I'm pretty confident that they would object. It is the same reasons that I wouldn't attempt to get this as 6455, and it isn't appropriate as such, that it is irrelevant to this case. Whether Tom, Dick, or Harry drove the car on June 28th or July 17th, or in any of the incidents prior to August 13th, do not prove more or less likely who drove the car that night. Those incidents are not charged, and in fact, they weren't all aimed at a car and not a man. In this particular case, Mr. Womack is charged because he is seen on video before the shooting and immediately after the shooting driving that white Charger. So whether or not his brother drove it, or his cousin, or his friend, or his girlfriend drove it, or other people drove it 2 months before, doesn't illuminate what happened that night. Mr. Duma has said it's relevant because he needs to prove that this vehicle was not solely operated by my client. It wouldn't matter who else operated it. That's not the person we see driving it before the murder and after the murder. That's why he is charged. Uniquely, the same rationale would apply when you're trying to challenge the probable cause of that warrant itself. So again, those crimes are not charged. They are ongoing investigations. Mr. Duma is right. But the reason why that wouldn't have affected PC is because the PC was not to get a warrant for Mr. Womack. It was not to get a warrant to arrest him or even to search his home. It was to get a warrant to track a car. Now, certainly who the car was registered to is a relevant fact. But again, evidence that other people used a car at a previous date wouldn't change that there was probable cause determined by a magistrate at the time to track this car. Mr. Womack was not the subject of the warrant. The car was, and uniquely, the inclusion of Tomias in one critical spot in the affidavit, Mr. Duma brought up at prelim, and it was the result of a typographical error based on the detective Bundy who filled it out. He's fully prepared to own that. And again, I would say that's not relevant. So I would object first and foremost on the idea that it wouldn't contribute to a defense in this particular case. The charges in this case are related to the evidence we have seen that put uniquely Mr. Womack in the car at the time of the murder, not based on an affidavit that got the tracking put on it. That's not the case here. I would also object that it is all ongoing investigations into serious crimes that have yet to be charged. And so I think it should not be granted for that reason. And if the court did feel the need to grant it, I would concur with Mr. Duma that we could work out a process. We would need to work out a process whereby I believe first, the court would review material in camera, determine what would need to be exposed to Mr. Duma, and Mr. Duma would have to review that. And we'd have to determine, as he discussed, some method. But I think that perhaps is putting the cart before the horse right now. But those are my objections. And I will just, for the record, address my standing issue, which I said initially, which is that Mr. Womack is the owner of the vehicle. He certainly can assert a challenge to something based on the tracking of the vehicle. While I understand Mr. Duma's argument that it might be interesting for Mr. Irvin or Mr. Henderson to know some of these facts, it is not Brady evidence, and they do not have standing to challenge a tracker being placed on a Charger that's not theirs.
Thank you. Mr. Stone, do you have anything you want to add on Mr. Duma's motion?
The only thing that I would say is I'm not really in a position to argue any type of suppression of the tracking information at this stage. But as far as discovery is concerned, I think it is important that we be permitted to review the tracker information prior to the date of the homicide. These individuals have been coupled by the vehicle. They've been placed in the vehicle before and after the car, and it's been asserted at least that they are the individuals that were in the vehicle before and after. If the tracking information shows a pattern with this vehicle, or it shows, I don't know what kind of discovery they have as far as that concerned. So as far as discovery is concerned, I think we're privy to that information because it's all part of an ongoing, res geste type thing with this vehicle. But I'm not in a position to argue about the suppression or anything like that of the tracking information. It's that I think we should be privy to the discovery.
Mr. Liker?
Yeah, Your Honor, I was actually going to say the exact same thing, but I think the discovery issue and suppression is something separate here. I think in terms of the discovery and what's already been discussed about my client being.
Jeff? You're cutting in and out. I'm sorry. You said you were basically going to say the exact same thing, and then you started in and out.
I think that my client is entitled to the information for the ongoing investigation itself. I think the suppression issue is separate, and I'm not in a position like Mr. Stone to have a position on that at this time.
Your Honor,
Yes, Mr. Sokoloff.
I guess just briefly, I would also add, the state is not alleging at this time that these three men were in the car necessarily for any of those prior incidents. I don't believe the identity of anyone in those cars is in that affidavit or alleged, again, beyond the idea that obviously Mr. Womack is connected to it as an owner. But again, who was in those cars on those previous dates is certainly relevant to another investigation, but not to this case. The men are placed in the vehicle, not by association with the charger, but rather by the visual evidence from August 13th. That's why they're the three who are arrested, because they're the three that we see on camera.
Mr. Duma.
Judge, I have to make 2 points which I think are important. Mr. Sokoloff keeps saying they're the three that we see on camera. I'm not sure who he's referring to. I think there was a single detective who might have testified as to their identity from what I would purport to this court to be a very bad video. So for this court to take the position that they've already been identified, or the state to take the position that identity is not an issue, that's not the case. We have the testimony of one detective at a preliminary hearing, and that's the only, I don't even know if he testified or if anyone really has testified that they have identified these people as the people who were observed in those videos. So identity is very much an issue. And one more thing, the shootings that I'm referring to in this affidavit, those reports that I'm asking for, refer specifically to 10mm guns being used and different guns that would have been consistent with the guns that were ultimately found in the vehicle. So if somebody else from a previous shooting left the gun in the vehicle, that's a defense. I'm sorry if at this time the state doesn't want to believe it, but Judge, that makes it relevant in and of itself. And we shouldn't really, I don't even think it should be given to you in camera. It's just relevant evidence. I mean, we could be given an order not to disclose it, you know, but I think it's absolutely relevant. And if we don't get it, it'll be a serious issue on appeal.
Identity is definitely an issue. Mr. Duma is right, but at no point will the information in that affidavit, the information being sought here, the previous half a dozen crimes, at no point will that evidence be introduced in this trial. At no point will that evidence be used to identify these three gentlemen. That
It'll be
won't
used by
be
me.
it.
It'll be used by me maybe to say that it wasn't them. That's the point. We may use it. We may want to use it. If it's Tomias, his brother, who looks exactly like him, who was taken in a picture with the vehicle, then I want to know that. And I want to say, oh my gosh, Tomias was committing shootings in this vehicle in the weeks going up to this event. I want to know that, and I want to be able to present that information to a jury.
Well, specifically the video from the 13th shows it. I mean, Tomias has a physical deformity that is recognizable on camera, and it is not him. That's one of the things we addressed in the investigation.
Has that been testified to? I mean,
Gentlemen, look, you're addressing the court, not each other. You can do that at a later time. Argue your case to each other. Mr. Stone, you had something you wanted to add?
Judge, just with regards to identity, you know, identity at a preliminary hearing is going to be a lot different than identity at a trial. You're talking about a question for a jury, and the weight of the evidence at the prelim is going to be a lot less than at a trial. And the fact that the civilian witnesses did testify at the preliminary hearing becomes even more important when we talk about identity, because we're having a detective who may have never seen these gentlemen before say, here they are in the video. Now, whether or not the jury believes the image that they're seeing on a video is this particular defendant, one or the other, is what will ultimately be weighed by a jury at a trial. Now, like Mr. Doom is saying, when it comes to identity, that to me, I'm not real worried about identity, but I do think it's important that, these guys are coupled in a vehicle before, after. Were they together before in the same vehicle? Had they been at the same location before at the same vehicle? Does the tracker show them circling this gas station or going to these gas stations on other occasions? I mean, nobody knows because we don't have that discovery. And so is there a pattern? Is there not a pattern? I think it's important that we at least be able to review the information. Whether it's admissible or not is a totally different question. But just to be able to review the information is something that we have a right to do.
Well, look, I'm fairly convinced, and you're all kind of talking in the wrong language here when it comes to discovery. Evidence doesn't have to be relevant to be discovered. It has to be reasonably designed to lead to admissible evidence. Okay, so there doesn't have to be a showing that it's actually relevant before it's allowed in discovery. My holdup on this is the ongoing investigations that are going on, because I'm kind of convinced here that allowing the attorneys to see it with a protective order, not to share it with their clients, what it does to what position it puts the lawyers in. So tell me why that wouldn't, let's say that what you see relevant information that tends to inculpate your client in another crime, another shooting. Then you've got to talk to him about whether he should testify or not. And you know this, but you're not allowed to reveal this information to your client given the court's order. What position am I putting the lawyers in if I allow you to review this evidence, but issue the order that you can't share any of the knowledge with your client? Mr. Duma.
It's an interesting question, Judge. I'm thinking about my duties that would be to him. I mean, obviously, I'd be able to follow the court order because the court order would be clear. I would disagree, I guess, with the court order to restrict sharing of the information with my client, only because that's the information that I need to share with my client. If it is him, I'm sure the state would seek to use that information in a 6455 motion. If it isn't him, I would be able to share it with him. Judge, I just don't know. I think, and maybe I could be wrong, but I would ask the state to tell us, to specify if these things are actually being investigated or if they've just been submitted and they're sitting in the office. Who's the detective? Are they actually being investigated? Or is this just something shootings that happened a while back and they're dead ends? Because a lot of times that's what happens in these cases. And if that's the case, I think that changes everything. I think that, and I wouldn't be surprised if the same detective, well, it looks like Bundy signed the affidavit. We could call him and say, hey, where are these still being investigated? Or, I mean, that would be my position, because these guys can't communicate other than, I guess, with other people in the jail to thwart. I don't know how they would thwart an investigation, them three sitting in the jail. So my request would be to allow us to share relevant information with our clients and nothing else as far as identifiers, just like we normally would share discovery. And a lot of times we'll get discovery that will implicate our client in other crimes or other wrongdoings, and that's not unusual.
Mr. Stone.
Did you say Stone or Sokoloff? I didn't hear.
Stone.
Judge,
You
I don't
raise your
think-
hand.
I think, I don't think I could follow the court's order if that's what you ordered. I think that the court would have to review the evidence in camera before it made any determination like that, because if you give us information about our, supply us with discovery regarding.
Hold on.
You broke up.
I'm sorry, I didn't realize I was muted. You're cutting in and out.
Okay. What I was saying was, I don't believe that I would have been able to follow the court's order, because if the court provides us or allows us information regarding whether it's whether it's guilty finding or or not guilty finding, we're going to try to use that information one way or the other, or not use it, or file a motion to have it not admitted. And I think if we're given information regarding our clients, we have to discuss that with our clients ethically, and zealously with our clients in their defense. I think, Judge, that an in-camera review would probably be warranted here if the court's concerned about releasing the information, to see if there is relevant information. And again, when we talk about relevant information, we also have privileged information that we hear from our clients. And I don't think it would be the court's determination whether relevant evidence would be something that could lead to discovery or admissibility at a trial without the court truly understanding all of the information that we possess from our client. And so when we're dealing with a vehicle that allegedly has 3 individuals in it, or 4 individuals, or 5, or whatever, before and after a shooting, we're dealing with a situation where the state possesses information where this same vehicle has been involved in other shootings with multiple individuals inside of a vehicle with the same type of weapons inside of the vehicle, same type of complaints, same description, everything. Now, our clients may not possess information regarding those other shootings, but the state possesses tracking information about this vehicle. They possess descriptions of individuals that were in this vehicle. Civilian witnesses in this matter, again, did not come forward and testify that they saw specific individuals in the car. They didn't come forward at all. We're dealing with a video, and it may be the information that we possess from our clients may be admissible if they decide to testify. If they say, this guy's been doing this and this guy's been doing this, I don't know, but it's the admissibility that we have to determine based on the discovery. And without getting the discovery, we don't know whether it's relevant or not. We don't know whether it's admissible or not, or whether it should be used in our defense. And so I'd argue to the court that, at least the court should do an in-camera review of the prior tracker information, or the discovery as to these other shootings, or information about this ongoing investigation, whether it is or isn't, and then make a determination at a minimum. I would argue that it should be provided to us, because you're talking about the possible murder weapons. You're talking about the vehicle involved in the murder. You're talking about a group of individuals in a near time frame. You're talking about the same tracker that was involved in this case, involved in other things. It's so closely related that not to let us review that information and review it with our clients would be
Mr. Sokoloff, last word.
Ultimately, I believe that these defense attorneys would rightly be standing up and protesting if I attempted to use this as 6455. These are, and I would say if we are to assume these gentlemen are involved in some or any of the prior half a dozen instances in the affidavit, they would just be prior bad acts. There is no connection here between them other than that. It was a car. Quite frankly, this car was being prosecuted, functionally speaking, by the state. A judge found PC to go after a car. And if we were to expose all of these ongoing, very serious investigations, the potential for them to all be deleteriously affected is huge, right? Evidence could be destroyed, stories could be gotten straight with people. The allegations on face in the affidavit involve more players than 3. Certain instances had more than 3 gentlemen at the car. We know then that it's not just these 3 men here. If it's these 3 men at all, could have been completely different people. But we are talking about a much larger potentially number of people involved. If not, we're talking about prior bad acts of these gentlemen, and to expose a bunch of ongoing investigations is not something we should be doing. And it's not as if we can just ask Detective Bundy or all of the detectives involved what the status of the case is, because that itself is potentially a vulnerability for the case, depending on where it is at. And again, I would just say none of those things make it more or less likely who was in the car on August 13th.
Without the need to be completely specific, how many other shootings, ballpark number, are we talking about?
In that affidavit, I believe there are 6, and I don't have it in front of me. I think Mr. Duma might.
All right, that's close enough. I don't need a specific number.
5 or 6.
The other question would be time frame. How long ago did these 6 or so shootings?
They were in the several months preceding this, but June and July for the most part. I think, Mr. Duma, you're muted.
I emailed to you as exhibits A and B, the affidavit and the order, because I would like those to be received by the court, because, and I'll note on June 28th, there was an instance with a black Charger. On July 18th, July 25th, July 29th, again on July 29th, and that's it. And then on August 7th, they got the tracker put on. August 13th, this shooting occurred. And Judge, I mean, we've got, they're talking in this affidavit. This is the affidavit they're talking about 10 millimeter shells being involved, 40 caliber shells being involved. I just don't see how I don't see how the state can say with a straight face that if they have evidence of a shooting that was committed by my client in the weeks preceding this, that involved the same caliber weapon that was located in the vehicle during this shooting, they wouldn't use it as a 6455. That'd be nice of them, but it would be eligible for that use. And regardless, Judge, regardless of whether or not it would conclusively prove that these 3 individuals were there on that night, I think, like you said, that's not the question. It's whether or not these are reasonably calculated to lead to discoverable material, and they are. And I think that'd be my argument, Judge. And one additional thing, I think I stand apart a little bit from these 2 additionally, because I have a 4th Amendment issue I'd like to investigate as to, because what it seems like in this affidavit is they're just seeing a Dodge Charger around. And then they find a Dodge Charger that doesn't meet the descriptions of what they'd seen in these shootings. And they decide that's the Dodge Charger who'd been involved in all these shootings. And so I don't see any real clear factual support for that warrant to have even issued. And I'd like to explore each instance to see if the facts actually do support the issuance of this warrant for the GPS.
All right, here's what I'm going to do. Look, I think it's a little disingenuous of the state to say none of this is relevant, because I read the transcript of the preliminary hearing. It was offered there. Now, it was offered at this tracker information as explaining further actions and how the detectives knew what videos to look at, things like that. I can't imagine that at trial, the same sort of thing's not going to be offered. I also think that Mr. Duma makes a point that, yes, a judge found probable cause, but if for some reason a motion to suppress was successful on the tracker information, that may very well limit. There's an argument to be made of what is fruit of that poisonous tree. And Mr. Duma has no way of knowing that without access to those records. Look, the good thing about this is, well, probably not good for the defendants, but the good thing is there's no rush on this because we're not delaying trial. So what I'm going to order is the state provide the court the records of all of the incidents referenced in the affidavit supporting the issuance, well, in the charging document and supporting the issuance of the search warrant for the tracker. The court will review, and only after seeing that will I make a specific determination of what the defense is entitled to and whether or not and what type of protective order needs to go along with that. Look, I understand that sometimes the ongoing prosecution of a murder case can sometimes jeopardize other investigations. However, that's the practice of law. Now, I need to look at them to make sure that there is something there that is worth the jeopardizing these other investigations, or if they in fact do at all. I don't know. So I'm going to order the state to produce these documents. And again, to be clear, it's the incidents referenced in the charging documents and also in the issuance of the tracker search warrant to the court for my in-camera review. Once I've done that, I am going to notify the parties of what my final decision is as to if defense gets access to it, if so, what, and under what circumstances. So I will take a look at these and see where it all falls. All right. That having been, I don't know that we even need to journalize that today because it's kind of pending my review of what my final order is going to be on that. But Mr. Stone, those issues that you raised, would you be so kind as to journalize those and distribute them? I'm going to take that. He's muted, but I'm going to take that as a yes. All
I
right.
said sure.
Okay. So I don't know. Here, Mr. Sokoloff, do you have an estimate how much time it would take you to gather those documents and get them to the court?
I mean, obviously, Your Honor, I have none of them. So I couldn't begin to estimate. I can tell you, and I think everyone in this room knows how long sometimes it takes to get a file from PD. I can't tell you in what state they are in. I actually do know for a fact that a couple of them are in a more developed state than perhaps others, and that might be more readily available, but I'll just have to circle with the detectives of the various units. They're not all homicides, obviously. There's different units here involved, persons, property, whatever, but I'll get them as quickly as I can.
All right. So I like to set hearings, particularly when I've undertaken to get an answer back to parties, because it sets a time frame for me. So if I were to set it, say the first week in September before Labor Day, Mr. Sokoloff, do you think I would have those reports in enough time to have been able to go through them prior to that?
I would hope so. I mean, I think it may be, quite frankly, just you'll get what they've gotten, and they won't be fully baked police files necessarily, but I'll just make it clear to the police that they need to give us what they have.
All right. Let me take a look at this. Denise, do you care where I set this? All right. Yes. Yeah, it's wide open. Well, how about September 2 at 9 a.m. And figure on just Zoom right now? What are my Zoom dates? Mondays. Okay, never scratch that. Let's look at August 31st. Also wide open. I could set it for a Zoom hearing at 9 a.m.
That's fine for the state.
Mr. Duma? Mr. Stone?
Fine.
All right, I got a sense from both of them. So, and Mr. Liker's here, it's good for him too. All right, so I'm just gonna put this on the status docket. August 31st at 9 a.m. I'll send out invites as soon as we're done here. Anything else we need to take up, State?
I don't think so, Your Honor.
Duma, Stone, Liker?
Judge, no, the only thing that was crossing my mind, and just out of an abundance of caution, how are we going to make a record of, if you make a decision to exclude evidence from us, how are we going to make a record as to what was excluded?
Well, that's kind of the idea of in camera. The record is that I decided that the documents did not have any real possibility of leading to relevant evidence, and therefore deny, or for whatever reason that I give, I deny it. That is your record. And at some point, that where it goes from there, you never know. But that's the whole idea of in camera.
Okay, I've never done this particular, I've never done it this way before, so that was my only question, Judge. Thank you.
Mr. Liker.
I was just gonna suggest that anything that's provided before it be scanned and kept preserved for purposes of appeal.
Michael, are you done?
No.
He's gonna suggest that what?
Mr. Liker suggests that anything that I review be scanned and maintained by the court for appellate purposes after the fact, and I have no problem doing that. I'm sure I'll probably receive them electronically, and I'll just keep them electronically. All right. Anything else by anybody? We are adjourned. Thank you, gentlemen.